Okay, so welcome to this episode of Advice Talks. It's been a wee while since we've done a podcast, but in this episode, we're going to discuss the Bankruptcy and Diligence Scotland Bill, which is currently going through the Scottish Parliament, and it's now going on to stage 3, which is the final stage of the bill as it passes through the Parliament. Now, this bill is quite a simple bill. It's only maybe got about 13 sections originally. And the main rule, most of the bill is basically quite what we would call just technical amendments. Although the main sort of headline sort of policy in it that is actually relating to a mental health moratorium. And just to explain what that is, a moratorium in Scotland, we already have moratoriums in Scotland, and we have a thing called a statutory moratorium. And if you need more information about a statutory moratorium is, you can visit our website, advicescotland.com. We've got a lot of information about that and how you would apply for it. But a statutory moratorium in Scotland is basically what we call a diligence stopper. It basically stops sheriff officers taking any recovery action against you, such as bank arrestments, wage arrestments, attachments of cars, and it also stops somebody petitioning for your bankruptcy as well. It's free to apply for. You can do it online, and it pretty much goes through within one working day. Or if you apply on a Friday evening, it'll probably be on by Monday morning. And it's a very effective tool if you're being pursued by sheriff officers. If you think you've had a charge for payment, which is a 14-day demand, and you're worried about what's going to happen after those 14 days. If you've never applied for one before, you could apply for a statutory moratorium. And it basically puts a hold on all the action for 6 months until you can maybe get advice and see what your options are. Now, a mental health moratorium is quite a similar idea, effectively. But what it does is it's going to be for people with mental health problems who are receiving compulsory mental health treatment. So it's not just for anyone with a mental health problem. So you wouldn't be able to get this just because you suffer anxiety or depression. You'd need to be mental health problems would probably need to be quite severe to the extent that you're probably going to be receiving compulsory treatment, basically. Now, at the moment, this is quite controversial in terms of the bill, because the bill itself, in relation to the mental health moratorium, it doesn't really have a lot of information in it. It's what we call a framework bill in Scotland, which basically means it provides a framework for the moratorium, but it doesn't really give you any details as to how the moratorium is going to work. And that's been one of the most controversial things about this bill.
I think we need to guard against this sort of legislation, which seems to be coming forward more frequently from this government. Because after all, and while I take the points being made by the government about the need to get this right, I would argue it's important to get those details right before you publish a bill, before it is put in front of Parliament, because that is what this place is for.
But the problem is one of the problems is if you don't have that sort of the detail in the bill, then ultimately, it does the rules, the detail comes later when the legislation or regulations are made. And the problem with a lot of regulations is when these are laid in front of Parliament, they're made by ministers, they're laid in front of a committee who normally gets about 40 days to consider them. And depending on the procedure used, whether it's negative procedure or affirmative procedure, there may have to be a vote or not. But if it's negative procedure and there doesn't have to be a vote, then the legislation just passes after those 40 days. There is not a stage 1 report, so you don't have the same sort of detail of reporting to Parliament that you get with a bill. And also on top of that, there's no opportunity to amend it. And that was one of the criticisms, the main criticisms of this Bankruptcy and Diligence bill so far, is that there really is not enough information in this bill for the Parliament to really scrutinise it. Now, I gave evidence in October 23 into the Economy and Fair Work Committee, who's the lead committee on this bill. And I made that point to the committee, and you can see that evidence that I gave right here just now.
What does this moratorium do? Right, the current statutory moratoriums stop all diligence and they stop somebody being made bankrupt unless a petition's already been raised for bankruptcy. What does this moratorium do? In England and Wales, their grievance-based moratorium stops somebody raising a court action. Ours don't. It freezes interest and charges. Ours don't. It stops cars being repossessed. Ours don't. It stops evictions. Ours don't. It stops repossessions. Ours don't. It stops prepayment meters being forcibly installed. Ours don't, which is an issue because that's a reserved matter for the UK Parliament. It stops debt arrears what do you call it? It stops arrears for electricity and gas bills being deducted from a pay payment year. Ours don't. So I think there's a big issue right here. What is this going to do that's going to make it better or more enhanced than a current statutory moratorium?
Now, one of the effects of this, I think, was that in November, the Scottish Government, as a result of that, then launched a sort of snap consultation in relation to the mental health moratorium. And that ran until January. Now, at the moment, and I think that was really because, quite rightly, the Parliament, then the Economy Committee, had, after taking evidence, had lots of questions about this mental health moratorium. How was it going to work? How was it going to affect people? And equally, who was going to be able to apply? Was it just for people that were getting compulsory mental health treatment if they were in a hospital, which is obviously quite a limited group, or was it going to be for people who were getting crisis mental health treatment but maybe still living in the community, which obviously would mean it would be available to apply for a lot of other people. But equally, as you can see for the evidence that I gave, what effect is it going to do? How is it going to work for people? So the Scottish Government did have that consultation in November, and I say it finished in January. And as yet, we still don't have the details or the results of that consultation. But the Scottish Government have said that they will try and bring draft regulations forward before the bill completes stage 3. Now, that's great. That's to be welcome. But it still means that as a result of what's happened, it still means that the Parliament won't have an opportunity to amend those regulations when they're eventually laid, unless the bill is amended at stage 3, which is the stage it's now on. And some more of that detail is included in the bill. Now, when the bill went through stage 2 of the Scottish Parliament, some of these amendments, there were amendments laid to try and sort of put some of the detail in the bill, but as yet, these weren't supported by the government. Now, one of the big problems we've got with the mental health moratorium is, first of all, who does it apply to? As I said, it could be for people that are getting compulsory mental health treatment, but only in a hospital setting. Or could it be for people who are getting compulsory mental health treatment, but in the community as well? Now, and there is some comparisons that we can look at to see how this would work. And then, for example, in England, they have a similar mechanism. It's not called a moratorium. They've got a more sensible sort of name, a more sort of user-friendly name, and it's called a breathing space measure. And their breathing space is very much like our statutory moratorium, although it does have a lot more powers. And on top of that, they're actually, as I say, they've also got another moratorium, another type of measure, which is called a mental health crisis breathing space, which would be similar to the Scottish mental health moratorium that's been proposed. But again, their mental health moratorium, or their mental health breathing space measure, does have a lot more protections, which even at this point, the Scottish Parliament, or the Scottish Government rather, are not proposing should be introduced into the Scottish version. So that would effectively mean that people in England and Wales would actually, if they use the mental health breathing space measure, they're going to have far more protections than Scottish people in debt in Scotland who have got a mental health crisis are going to get if the proposals by the Scottish Government, as they're currently proposing it, go through. Now, the reason why this is important as well is because we can look at the English measure and the English and Welsh measure. And if you were to look at the number of mental health breathing space measures there are compared to the actual number of just normal breathing space measures there are in England and Wales, and compare that, extrapolate that, and compare it with how many statutory moratoriums we have in Scotland to work out how much mental health moratoriums there would be in Scotland, then you're probably talking about 40 or 50 people a year being able to use the Scottish mental health moratorium. So that's not a huge number of people it's going to help. So that's one of the most disappointing things about this legislation, is it does seem that it's going to not give people in Scotland is anywhere near the same level of protections that people in England and Wales will have. And equally, it seems that it's going to affect or benefit a very small number of people. This is quite concerning because the work for this bill has actually been going on for quite a long time. And it's really what had happened is that the Scottish Government had launched a review into Scotland's debt solutions in 2019. So we're probably talking about 4 years. And there was lots of working groups basically set up to look at the whole ambit of Scottish debt law in terms of, debt solutions. And basically, there was a lot of, I sat on one of those working groups and on the ministerial working group, and I know the huge amount of work that was done. So the fact that, we've done all that work and looked at so many ways that we could actually protect people or improve the laws in Scotland in terms of helping people with debt or with problem debt. And the result of that after 4 years has been a bill which some people have described as being basically a nothing burger, because it really does very little to help people in debt. And especially just now during a cost of living crisis, when they really probably should be using the full range of powers that the Scottish Parliament have got to help people. The fact is that at the moment it looks like this bill is going to be is very disappointing, and it's not going to really amount to much or help very many people. So all we can do at the moment is obviously wait to see what the results are back from the Scottish Government's consultation that was launched in November and finished in January, and then we can look at maybe hopefully there will be draft regulations and the parliamentarians in the Scottish Parliament will be able to look at this. But there's debt and mental health is a huge problem, and it causes a lot of social ills and a lot of distress for lots of people. So we can only hope that as this bill goes through its final stages, that we will see parliamentarians coming in and possibly laying a lot of amendments. Now, one of the reasons why the Scottish Government have argued that they don't want to put so much detail into the actual bill itself and tell us, what this moratorium is going to do, is because their view is that, if you can make things by secondary regulations, then it's easier to change it. So you can actually bring this moratorium in. If it's not working the way we want it to work, we can then change it and amend it to make it more effective. Now, that's actually true. It's certainly a lot easier to actually make laws by regulations, but equally the downside of that is it means they don't get scrutinised as much, and there's less opportunity for Parliament to actually interrogate those laws and to make sure they're the right laws that we want. And one of the, for example, to give you an example, one of the most concerning things about this moratorium is that there's a suggestion that there will be a public register that will allow people's names to be published. And obviously then people, if it's a public register, will then be able to access that register. Now, that's sort of true already with the statute moratorium at the moment. So, you can go onto a website, you can search for somebody on the statute moratorium, although you need their full name and their postcode, and that's to sort of put some sort of privacy restrictions on it. But if you find somebody on that the current statutory moratorium register, all you know about that person is that they've got a moratorium. What you don't know is why they've got that moratorium. You don't know if it's been because of a marital breakdown. You don't know if it's because they've lost their job. You don't know if it's because they've got a mental health problem, or maybe they've just overspent their money a wee bit. But you know that they've got a moratorium that puts a hold on all their debts, or certain types of recovery action being taken against them for being in debt. But it doesn't tell you the reasons why. The problem with having a mental health moratorium public register is that if you were able to search that and find somebody, then you're going to know, for example, that person is receiving compulsory mental health treatment. So there's been a lot of concerns that that this new measure, and if there's going to be a public register, could really basically create real data privacy issues for people, where people's personal sensitive data is being made public, really sensitive data about people's mental health.
Does he also share concerns that I have and other people have expressed about the government's stated intention to create a public register of those who would make use of the scheme? No such criteria exists in England and Wales. Does he agree with me that it ought not to exist in Scotland? And in terms of stigma, it's very important that this is handled very sensitively.
And that has been one of the concerns, and that shows you why sometimes, even although it can be easier to make laws through regulations, it shows you why sometimes, you still need to sometimes take the longer approach and put it through sort of primary legislation through Acts of Parliament, so that Parliament can fully scrutinise, because it can have some serious consequences, laws. So, we don't always want to make laws quick and easy to make. Sometimes it's more important that we make sure that the laws are the right laws. But there is some justification for the Scottish Government's point of view that it's easier to make things and change things using secondary legislation. But equally, that doesn't mean that you don't need to put the details in the bill. And so, for example, there is lots of bits of legislation currently in Acts of Parliament in Scotland, in things like the Debt of Scotland Act and in the Bankruptcy and Scotland Act 2016, where there is detail in the bill, the actual Act of Parliament, about what the law is, but it then gives the ministers the powers to vary that or change it at a later date. So even though the Scottish Government have argued that, you know, it's better to make to give the ministers the powers to change the law in terms of secondary legislation, because it's more flexible. It means that when things aren't working, we can change it quickly. The other argument against that is, even if that is the case, it doesn't mean you can't put detail in the legislation at the moment. So you could put detail in the legislation, for example, that said that a mental health moratorium could stop evictions, it could stop repossessions. You could put detail in the bill at the moment that says it's applicable to people that are, receiving compulsory mental health treatment in the hospital, and people that are receiving compulsory mental health treatment in a community. But then say, that ministers or Scottish Government ministers may, by regulation at a later date, change some of this criteria. And it would at least give us a starting point. So I don't think the Scottish Government's arguments in relation to why this framework bill has been used and why there's so little detail in it is really stands up to scrutiny. And in some ways, I would even argue that, what it did reveal is that although they're bringing forward regulations for this new mental health moratorium, they really don't know what it's going to do. They really haven't decided yet. And I think that's a really reprehensible thing, to bring forward an Act of Parliament to change the law, to try and give ministers powers to make further laws at a later date with far less scrutiny than you would actually get if it was an Act of Parliament, when you don't actually know what it is you want. I mean, you would have thought after 4 years of work when all those working groups were working and reviewing the debt solutions in Scotland, you would have thought that the Scottish Government would have sort of got an idea or an opinion as to what it is they wanted before they lay the regulation, before they lay the bill in front of the Parliament. And I think if you need any evidence of that fact, it was a fact that in November 23, they actually called that snap consultation because they were getting, quite rightly, a lot of criticism from the Parliament as to the fact that there was no detail in the bill and they were not able to give any detail. And I think fundamentally the reason for that is they didn't actually know what they were going to do, which is quite concerning. But the other thing I would like to say about this bill as it goes through Parliament is the fact that, it contains so little to help people in Scotland who have got who are struggling because of this cost of living crisis. As I say, there was a 4-year review. Lots of things were discussed, things like earners arrestments, bankruptcies, in terms of how we could make bank arrestments, etc., and how we could make the law fairer for people in Scotland. And the fact is, the bill has touched none of this. And one of the reasons the Scottish Government have actually says that is the case is because their argument is that they're now launching a third stage review. Now, we've already spent 4 years basically doing, reviews and working groups. It's taken up a lot of people's time who work in the advice sector and other sectors, creditors and stuff, to actually review Scots law, for them to get a bill which is very light. It's very light on the ground. It doesn't really contain a lot of protections for people, which at a time of a cost of living crisis, you would have really hoped that this bill would have contained a lot more information and details. And then to actually say that, the reason we're not doing this at this stage is because we want to do a further review, a stage 3 review, which, is realistically going to take 2 or 3 years, which means, and then by that point, there's going to be a 2026 election in the Scottish Parliament. We're probably going to we might get another Scottish Government, a different Scottish Government, a different composition in the Parliament politically. And there's no guarantee that at that stage that there would even be any legislation brought forward. So the truth of the matter is what we need at the moment is more protections for people in Scotland in debt, people that are really vulnerable, to really tackle this problem, problem debt. And the reality is that the Scottish Government have brought through very little, and also, what they seem to be doing is kicking it into the long grass. And sort of suggesting that maybe in 3 or 4 years' time, they might bring forward further measures when they may be required then, but equally, they may not be required. So I think, in some ways, I was listening the other day to, Kate Forbes, and I think she was, speaking on one of the podcasts, obviously a former finance minister in the Scottish Government. And I think one of the criticisms she made during that, as an SNP MSP and unsuccessful, someone who'd done really well in the Scottish SNP leadership elections only last year, but obviously was pipped at the polls by Hamza Yousaf. One of the points that she made was that, she doesn't believe Hamza Yousaf, the current First Minister, has got really any big ideas in terms of what he wants to do in Scotland. And I think, there was also another article the other day by, I think it's Kenny Farquharson, the journalist who was writing in the Times. And basically, he says, he was talking about another bill, which was the hate crime, or another law, the Hate Crime Act. And what he was saying about the Hate Crime Act is that, this is just another piece of evidence that the Scottish Government aren't very good at doing the hard thinking. And I think that's exactly what we've got here with this Bankruptcy and Diligence bill. We've got another piece of evidence of a Scottish Government piece of legislation, a policy that really doesn't contain a lot of details. There isn't any big ideas in this bill in terms of how we're going to tackle the issue of problem debt, especially as a result of the cost of living crisis and COVID. And it just strikes me that the civil servants involved with this, the Scottish Government ministers involved with this, are just not really able to do the hard thinking in terms of how we solve the hard problems in Scotland. And if I can give you some examples, of how we could be improving Scots law and how the sort of examples that we can include in this bill to make it better. At stage 2, a number of amendments were actually brought forward. And at the time, they weren't moved by the MSPs to a vote. But it may well be that we see some of these amendments come back in stage 3. At the time, the Minister, Tom Arthur, had suggested that we need to have further discussions about this. So I think the MSPs that had led these amendments, they sort of decided not to push them to a vote in the hope that maybe that some of these discussions that they had between the Minister and themselves before the bill got to stage 3 could be fruitful, and we could maybe get some sort of consensus between parliamentarians as to how we can improve this bill. But if you take some of them, for example, Paul O'Kane, the Labour MSP, he brought forward suggestions that would mean that, that from council tax debt, which is a huge problem debt in Scotland. I mean, if you were to look at the Improvement Service figures on this, the Improvement Service is an organisation that works with local governments in Scotland, and each year they collect all the sort of debt, a lot of statistics and information from advice agencies like Citizens Advice Bureaus, local authority advice agencies, law centres from across the whole of Scotland, the whole 32 local authorities. And what their evidence, what their statistics called the CAP-MF statistics show, is that council tax debt is actually the largest single debt that advice agencies in Scotland have to deal with. So I think it works out as about 16% nationally. But in some local authority areas, because it does a breakdown for each local authority, in some local authority areas it's almost 20%. So it's almost like £1 in £5 of all problem debt that people go to advice agencies like the Citizens Advice Bureaus is actually council tax debt. And if you listen to organisations like Step Change and Citizens Advice Scotland, they say the exactly same thing, that the biggest debt that they're dealing with at the moment is council tax debt. So council tax debt is a huge problem in terms of Scotland, in terms of how it's one of the largest debts that people deal with, and I say almost 20% in some places of all debt as that people go to Citizens Advice Bureaus and other advice agencies about as council tax debt. And one of the things that Paul O'Kane had actually tried to put an amendment forward in relation to was to include things called what he was calling as a pre-action requirement. So before local authorities could actually take any further action against somebody for not falling into their council tax years, that they would need to take some steps, pre-action requirements, to try and help some people in debt. Now, this was actually objected to by Tom Arthur, who's the minister. He certainly didn't support it. And one of the reasons he gave, bar anything else, was, he says that, we already know that the advice sector in Scotland is already under quite a lot of demand, and that's certainly true. It's obviously, it's almost creaking under the existing level of demand. And for that reason, he says that, we shouldn't do anything that makes that situation worse. Now, that sounds quite reasonable. We don't want to put our advice agencies under more demand, but to give you an example, or make a comparison, that'd be like saying to people, because the NHS is under a lot of pressure at the moment, You know, if you split your head open, or if you think, you know, you start having serious ailments, that you shouldn't go to the NHS, or you shouldn't go to the accident emergency, or you shouldn't go to your GP to try and get those, you know, to see, you know what's wrong with you and whether you know there's some help that, you know, treatment you may need. So it's a bit like that, you know. It's saying because of the demand that currently advice agencies are actually under, we shouldn't actually introduce pre-action requirements for local authorities to try and to encourage people to try and get advice before, you know, the situation gets a lot worse. I mean, that's absolute nonsense. So I would hope that we could actually see that amendment being brought back by Paul O'Kane, or a variation of that amendment being brought back in the stage 3 of the bill. It's definitely the case, you know, that, you know, if a lot of people were able to get advice sooner and earlier, then steps could be taken to try and prevent, you know, the situation getting worse. So that, you know, people, for example, if people did fall behind with their debts, you know, their council tax arrears, you know, and they were at risk that they were going to get a wage arrestment, or they were going to get, you know, a bank account arrestment, then these people could actually, if they were able to go and get advice, and even if it was going to take a couple of weeks or months before the advice agency was able to help them, they could, going back to, you know, what I was saying earlier, they could use a moratorium. And that could give them 6 months protection in order to get advice. And that could maybe prevent somebody not being able to pay their rent, not being able to pay their mortgage, falling behind with their car finance agreements. So I think, you know, what Tom Arthur's reason for asking Paul O'Kane no to go forward with that amendment, which was to try and avoid putting too much pressure on advice agencies, is basically a nonsense. Do you know what I mean? And we could do a lot more to help people if we were able to get them advice beforehand. So I would certainly support Paul O'Kane's amendments that were laid at stage 2, and I would hope that they will come back. Another sort of suggestion that's been brought forward is in relation, again, to council tax. It's in relation to earners' arrestments. Now, in Scotland last year, there was over 53,000 earners' arrestments, or as we sometimes call them, wage arrestments, which is where people get their wages arrested. Now, at the moment, if you get your wages arrested, the first £655.83 is protected by law. And after that, then they take 19% of your earnings. And once you get to, I think it's about 2,300, they take about 23% of your earnings. But what this basically means is that a lot of people in very low incomes, under £1,000, are getting money deducted from their wages to pay basically their debts. And I think it's approximately about 91% of all wage arrestments in Scotland are actually for council tax. Not all of them, but, you know, about 91%. And that then pushes a lot of people into hardship. And part of the problem with this is because wage arrestments apply, that formula I've just described applies to people regardless of their circumstances. So you could be a single person and you can have a wage arrestment for, you know, basically, and, you know, obviously it's taking 19% of your income after, you know, your earnings over £655. But you could also be, and that I was dealing with someone the other day, you know, had 7 people in the house and there was only one income, you know, and they were actually, they were getting this wage arrestment taken. So obviously it has a far more disproportionate effect on that household, on that family, than would be if it had a household, you know, who was just a single person. So, you know, there are serious concerns and problems with wage arrestments. They can be very harsh sometimes. And again, this was an issue that actually came up with when I was given evidence to the Economy and Fair Work Committee with the bill coming through the Scottish Parliament in October. And you can listen here to the Citizens Advice Bureau manager, Natalia from Citizens Advice Bureau in Dalkeith says.
Would impact on your client?
I fully agree. The level is not appropriate at the moment. It is adding to energy poverty. It's adding to child poverty. The wages, when they are arrested at the current level, we often have families where only one person works. So if that amount of money is arrested from their sole income, it really leaves families in destitute, severe financial hardship. And there is just nothing that we can do to try and alleviate it to the level, to bring it back to the level where people can cope.
Now, one of the proposals that were put forward was by Colin Smythe, the MSP for South Scotland, and he suggested that we increase the protected minimum amount in wage arrestments up to £1,000. Now, this would bring that would mean the first £1,000 would be protected, and then it'd only be 19% after that, which would bring some very limited protections to a lot of people in low incomes when they get their wages arrested. It would also bring this area of law, the earners arrestments, into line with bank account arrestments, because currently in Scotland, the amount that was protected in wage arrestments and earners arrestments used to historically be the same since 2008. But what actually happened was when the Coronavirus Recovery and Reform Bill was going through, something that we campaigned for a lot for in Advice Scotland was we argued for the amount that was protected in bank account arrestments. This is where your money's paid into your bank account and then your bank account is arrested. And we argued for that amount to be increased to £1,000. And we gave evidence to the COVID-19 committee, and then later we gave evidence to the Social Justice and Social Security Committee when they were doing their inquiry into low income and debt. And eventually, there was actually an amendment laid with the Coronavirus Recovery and Reform Bill by John Mason, the MSP for Shettleston, for the Scottish National Party MSP, and that was carried. So in November 22, the level of protections for a bank account arrestment in Scotland was increased to £1,000. Now, at the moment, however, there still only remain £655.83 in terms of wage arrestments. So if obviously that level of protection was increased to £1,000, then that would bring bank arrestments and wage arrestment protections into line again. It would also bring it into line with bankruptcy itself. Now, bankruptcy is sometimes in Scotland called the ultimate diligence or the ultimate debt recovery. It's the most harshest form of debt recovery in some senses, although the majority of people use bankruptcy nowadays to actually get relief from their debt, but it can still be used by creditors to actually to recover debt. Now, if the most harshest form of diligence in Scotland allows you to have £1,000 in your bank, which is what the case is in terms of bankruptcy, if you've got £1,000 in your bank and you go bankrupt, then that would just be disregarded. Then it would seem to make a lot of sense if we were to include, that the level of protections for lesser diligences, lesser forms of debt recovery, obviously like bank account arrestments and earners arrestment, to have the same level of protection. Now, this obviously proposal is not without some controversy. Both a lot of COSLA, for example, and a lot of the councils have raised concerns that obviously this would mean that they could lose millions of pounds of money that they recover. And obviously, councils need to recover council tax debt because obviously it pays for a lot of vital services, and those services primarily benefit the lowest income people. So the people that would probably suffer if these services weren't being provided are the most vulnerable people. But equally, you need to ask yourself, is it right that that in order to provide these services, we're arresting wages in a way that's so harsh that it's actually hurting the people and making more vulnerable the lowest income peoples. Now, at the time, obviously, the minister he does say that he had a lot of sympathy for the motives behind the supposed amendment by Colin Smythe, and he asked Colin, obviously, not to move the amendment until allow further discussion to take place, and Colin did do that. So hopefully we might see some progress coming out of that, the discussions, and maybe we see another sort of proposal coming forward in stage 3 of the bill. But one other option we could look at, for example, and this is something, again, Advice Scotland has been arguing for, and we gave evidence to the Economy, the Social Justice Committee, when they were actually doing their inquiry into low income and low and debt in relation to this, and that is to include the power to vary wage arrestments. So at the moment, as I say, if you basically get your wages arrested, the local or the sheriff officers will apply a simple formula. The first £655.83 is protected. After that, they take 19%, and that applies whether you're a single person or whether you're a household of maybe 4 or 5 people. Now, councils don't have any power to vary that. So effectively, what that means is that if say that was £200 that's to come out your wages, that £200 has to come out your wages. They can't reduce it. They can't make it any smaller because of your household circumstances, and that's quite unusual because in Scotland there's actually about maybe 4 or 5, or it's actually about 7 different types of wage arrestments. Some of them are UK based, some of them are bespoke for bankruptcy and protected trustees. Some of them are due to child maintenance. And about 5 of those types of wage arrestments of the 7, they're actually they can be varied. So, for example, a direct earners attachment is actually a type of wage arrestment that can be used by the DWP, HMRC, and also local authorities in Scotland in relation to recovering housing, overpaid housing benefit or other benefits like tax credits. Now, at the moment, if you get a wage arrestment or direct earners attachment, then you can obviously contact the DWP or HMRC or your local authority, and you can ask them to vary the amount because it's causing you hardship, and they're allowed to do that. They can actually maybe say, instead of taking 10%, it only takes 5%. Similarly, with direct earners deduction from earning orders, these that are to do with child maintenance, these are based on an assessment of your income, but if your income changes or if your needs change, then obviously a new assessment can be carried out with the child maintenance service, and they can vary the amount that is taken off. And in relation to bankruptcy and protected trustees, when you go into one of these solutions, you need to obviously agree to make payments from your disposable income to your debts. And if you were to lose your job, for example, during the bankruptcy, and say before you had been offering to pay £200 a month, and you were to, and that's been deducted from your employer, which it can do, then basically you can obviously ask for a variation, a review to be done, and the amount that's to be taken off your wages can be reduced. And that's something the accountant in bankruptcy can do themselves, which is ironic because one of the people that have actually opposed doing this for wage arrestments in Scotland is actually the accountant in bankruptcy, which is a Scottish Government agency that advises the Scottish Government and the Minister Tom Arthur on debt. And basically what they're saying is that this would be really difficult because it might mean that people are changing the amount that's been deducted from their wages, and that this may not be possible by employers, which is obviously an absolute nonsense because they themselves have this power in terms of contribution orders for bankruptcy. We know that the DWP has this power in terms of direct earners attachments, as does the Child Maintenance Service in terms of deductions from earning orders. So to say that we couldn't include the power to vary an earners arrestment in Scotland because it may not be possible for the employers to do so is nonsense. It's blatant nonsense because it already happens, say, for about 5 of the 7 different types of wage arrestments in Scotland. And the reason why this variation power would be really important is because what it would mean is, say you're getting your wages arrested and you have got a larger number of people in your family, it's not just a single person household, then you could contact your local authority. You could say to them, well, it's 5 years in this household. The amount you're taking means I can't pay my rent, I can't pay gas and electricity, and my children are going to go hungry. And the local authority could then say, well, take that into consideration. We're willing to reduce the amount that's getting taken each month. But it would also mean that the local authority still gets the wages deducted each month from the employer. So it means that they're still guaranteed to get some money coming in each month. But it also means that the arrestment can be flexible enough so that it's not causing you undue hardship. Another reason why this variation power is really important as well is because a lot of people basically have wage arrestments for a year's council tax, and then the next new financial year begins, which is obviously about to begin just now. And the big problem is a lot of people then can't pay their current council tax because they've got a wage arrestment for last year's council tax. And that just means that then they get into arrears again with the current council tax. Once they've missed a payment, they get a 7-day letter. Once if they've not paid it within those 7 days, then they get another 14-day letter, which demands a full payment, the full year's council tax. If they don't pay the full year's council tax within those 14 days, then they get a summary warrant. That adds 10% of the debt back on a surcharge of 10% onto the debt. And then what happens after that is basically, it goes to sheriff officers who serve a charge of payment, which costs £96, and that gets added onto the debt. And then possibly then they've got another, when one wage arrestment ends, then they'll just put another wage arrestment on. So giving local authorities the power to vary wage arrestments could be really, really helpful, because what it would mean is that somebody could go to the local authority in March, say, in March when the new council tax bill comes out, and say to them, I want to vary my wage arrestment. I want to reduce the amount that I'm paying so I can pay next year's council tax. And that then allows people to escape the vicious cycle of debt that they can get trapped in. It allows them to avoid further sheriff officer fees. It allows them to avoid a 10% surcharge. So giving councils that power to vary would be a really, really useful, really useful innovation to introduce into this bill. It wasn't an amendment that was laid in stage 2. But it may well be, and I would hope that as it goes to stage 3, that we could see this power to vary wage arrests being included, because I think that would help a lot of people avoid undue hardship, and I think ultimately it may actually help basically a lot of people escape the vicious cycle of debt that a lot of the people find themselves in. Now, another thing that was actually laid during the stage 2 of this bill going through Parliament was again by Colin Smythe, the MSP for the South of Scotland. And what he had proposed was an amendment which would actually put into legislation what is currently the law in Scotland and has been for probably the last 111 years. And that relates to what happens when somebody gets a bank account arrested, all the funds in the bank account are actual social security benefits. Now, the first case that really dealt with this in Scotland dates back to 1913, and it was a case called Woods versus the Royal Bank of Scotland, and it was heard in Greenock Sheriff Court, and it related to a piece of legislation called the Workman Compensation Act. And what had happened is Mr. Woods had got his bank account arrested, and the only money that was in his bank account was the payment of this social security benefit, which was. And what the court held in Woods in 1913 was basically that this legislation was protected, or that this money was protected from a bank arrestment. Now, the sheriff actually went out the reasons for this at common law, which because in Scots law has always protected elementary amounts of money from arrestment, and that includes basically money that people need to live on. But it also held that, in the case of the Workmen's Compensation Act, there was actually statutory protections in the legislation. Now, more recently, in more modern case law, there's been more modern case law, and there's a case called North Lanarkshire Council versus Crossing, which was heard in the Airdrie Sheriff Court by Sheriff Principal, which was the most senior judge at that time in that sheriffdom. And he basically held the same thing in relation to another piece of legislation. In this case, it related to a piece of legislation called the Social Security Administration Act. And a section 187(1) of the Social Security Administration Act. And what basically he held again, in that case, Crossing had only benefits paid into their bank account, which was, I think, the Airdrie Savings Bank. And when it was arrested by North Lanarkshire Council, they obviously challenged this and says you can't arrest us because it's only social security benefits. And Sheriff Principal Kearney in that case actually held that this was the case, and obviously and decided that in the case of Woods, which was obviously in 1913, had been decided correctly at the time. Now, the legislation, the section 187 at the time, what it says is that basically that any charge that's placed on funds that are actually only social security benefits are protected by law. And they held that basically a bank account arrestment was a type of charge, and so therefore, this protection that was in the Social Security Administration Act extended to protect benefits from bank arrestments. And now, only last year there was another case. It was called Mackenzie versus Edinburgh, the City Council of Edinburgh, and that was held in Edinburgh Sheriff Court, and that also related to Section 187 of the Social Security Administration Act in relation to universal credit. And what happened in that case is Mr. Kenzie, similar to Crossings and similar to Mr. Woods in 1913, had actually had their benefits arrested in their bank account. In this case, it was universal credit. And again, because of the benefits could be identified, they hadn't been mixed in with other funds or earnings and stuff like that. And they could be identified as purely social security benefits or funds that were purely derived from social security benefits. Again, in that case, the judge upheld the decision that had actually been held in both Woods and in Crossing and said that these benefits were protected. Now, the problem is in Scotland, the fact that 111 years after, or 100 years after Woods, we're still getting cases like Mackenzie going to court, shows that even though the law is quite clear in this, and it has been quite clear for quite a long time, and the legislation has been made by both the Scottish Parliament in terms of UK-led social security benefits, and also the UK Parliament in terms of UK social security benefits, but has also been made by the Scottish Parliament in relation to Scottish social security benefits, and this was done in 2018 with the Social Security Scotland Act, with Section 83, which has a very similar clauses to that exists in the 1992 Act of Section 187, that basically benefits cannot be subjected to a charge. And basically in Mackenzie, the judge held exactly the same thing, that a bank arrestment's a charge. So that shows that even though 100 years has passed and the law is quite clear, people do still get their bank accounts arrested, and even when those funds in those bank accounts are still wholly derived from Social Security benefits, creditors still don't accept this, and so these cases still have to go to court, and this can take months and months and months, and it means that people who, Parliament has decided, both the UK and the Scottish Parliament have decided that these benefits should be protected. These people are denied those benefits. So what Colin Smythe was trying to do with his amendment was basically put that protection into legislation, so it was crystal clear, it was beyond doubt, and hopefully that would avoid in future any when people did have their bank accounts arrested, that avoid any doubt that basically that those benefits, if it's only benefits in those accounts, that those were protected. Now again, the Scottish Government unfortunately were not had asked Colin Smythe to withdraw this. They weren't really supporting it, although Tom Arthur, the Minister, did say, it was sympathetic, and we can hear what Tom Arthur said here.
As well. Turning to Amendment 25, I understand that it seeks to put a recent decision of the Sheriff Court onto a statutory footing. The aim of this is to prevent attachment of funds in a bank account when those funds are solely derived from Social Security benefits. I am sympathetic to this aim, but I believe it needs further consideration and consultation with stakeholders. In particular, there are practical considerations on how banks would apply the rule and identify funds which are wholly from benefits. And of course, I want to ensure that any amendments along these lines are on the right side of the Social Security reservation. I am happy to consider further what needs to be done in addition to the existing protection. I'm therefore grateful to the member for bringing forward Amendment 25, as it highlights some of the issues which we need to consider and consult on. The amendment lists 8 Social Security benefits as included, but we need to consider whether others should be included and how any list would be future-proofed. The amendment requires the funds to be wholly from benefits and leaves the facts of this to the judgment of the creditor before funds are released. That might be difficult in practice. And how would any change here interact with the protected minimum balance as well? Again,
now, the reasons Tom Arthur gives, they're basically, I think they're a bit doubtful, to be honest with you. I mean, the first thing is in terms of, he talks about the protected minimum amount and how this protection, this idea that, when you get a bank account arrested, that the first £1,000 is protected, regardless of the source of funds. What Tom Arthur basically says is that it doesn't know how that protection, it's not clear how that protection would work with the wage arrestment protection. And I think the first thing is that's absolute nonsense, right? Because in even Mackenzie and in Crossing, this issue was touched upon and considered by the judges, and they said that the protection of Social Security benefits is an addition to the protection that exists in relation to the protected minimum balance. So that's nonsense. Second of all, it is this question about how the banks would be able to decide whether something with Social Security benefits or not. Now, this is maybe a practical issue that maybe Tom Arthur maybe doesn't appreciate, not being an advice worker. But the reality is that banks in reality don't decide. What actually happens is when somebody gets their wages arrested or their benefits arrested, they go to a local advice agency, or they contact the sheriff officers, or they contact the local authority or the creditor if it's a different type of creditor, and they basically tell them these are all benefits. And normally what they would then say is, right, you need to prove that, which is fair enough. So they would need to probably provide a couple of bank statements to show that the only source of funds going into that account is benefits. So it's not something that banks have to decide. It's something that the creditor would decide. And the person in debt who's had their bank account arrested would provide evidence to confirm that the only source of funds were benefits. But even taking that consideration, the concern about how this would affect banks into consideration, in his amendment, Colin Smythe had actually put a waiver basically in his amendment, which basically says, if banks by accident or in good faith arrested somebody's account, not realising that the money was benefits, and even released those funds to the creditor by not realising they were benefits, then they would have no responsibility whatsoever or any liability for that. And so, the concerns that was raised with the Minister, Tom Arthur, at the time are just groundless and don't make any sense whatsoever. So really there is no sort of really good reason why this amendment couldn't be brought back into stage 3. And I think most people would probably accept that Social Security benefits should be protected. And certainly the parliaments, both in the UK Parliament and in the Scottish Parliament, have taken this view before. They've passed this legislation to give this protection to people. Unfortunately, and whenever these cases for the last 111 years have went to court, then that's the law has upheld. The courts have upheld it. They should be protected. So I really don't see any reason why this shouldn't be put into legislation to make it clear to creditors that this is the law, and so that we can avoid this happening again in future. So the final thing maybe that I would like to see being brought into this bill, and it's a really important one, is that, and I've touched on it already, and it relates to what happens when, for example, your debt gets passed to a sheriff officer. So a sheriff officer is an officer of the court. They're used to enforce recovered debt using an area of law called law of diligence, which is basically coercive form of legal debt recovery. It usually is done through things like wage arrestments, bank account arrestments, and basic attachments to cars. Now, what currently happens is, for example, if we take the example of the wage arrestment, at the moment, that wage arrestment a wage arrestment schedule has to be served on the employer by the sheriff officer. Now, in the current legislation, as it currently stands, what the legislation in relation to earnings arrestment says is that, a wage arrestment should be served by post, recorded delivery, or registered delivery. And that's called postal diligence. So that adds on another 40, I think it's now £48 or so in sheriff officer fees onto the person's debt. And it's only if that form of service isn't possible, then sheriff officers can use what's called personal service, which is where a sheriff officer actually goes to the employer and hands over the actual earnings arrestment schedule. And the reason that's important, that you need to try postal diligence before you use personal diligence, is because the cost of personal diligence is £96, whereas postal diligence is about £48. So it's less than half, or it's about half effectively of the price. So that's money that gets added onto people's debt. Now, when there's 53,000 wage arrestments a year, that's obviously a lot of money. Now, what actually happened in this, when the bill was going through stage 2, is that the Scottish Government had actually laid their own amendment in terms of how wage arrestments are served on people. And what they were trying to do, they say, was to introduce a form of service known as digital service, which means it could be sent by email, which I disagree with. It seems completely sensible that we modernise our law in that way. However, what they also did is they took away the requirement that the sheriff officer had to first try and use postal service or even electronic service before they used personal service. So that was really a loophole that was being created there with the Scottish Government's amendment. And the effect of that loophole could have led to millions of more fees being added onto people's debts, because sheriff officers could then have just started using personal service rather than actually using postal services. The law currently requires them to do so. So I raised this with the Scottish Government, and I raised it with Accounting and Bankruptcy, and they did come back and have accepted the concerns I've raised about how this could lead to millions of pounds more fees being added onto people's debt has been confounded. And what they've actually said is that this was not their policy intention. So Tom Arthur, and we can listen to him speaking about this here in a moment, but Tom Arthur has said that in stage 3 he will bring forward amendments to try and change that and restore the law back to the situation it was currently, and with the actual postal service or the least expensive form of service, such as electronic service, will be used first. But here's Tom Arthur speaking about that.
Personal delivery and by post. It has been brought to my attention by Alan McIntosh, who I know the committee has had some engagement with, that Amendment 14, as currently drafted, may have some potential unintended consequences encouraging personal service, which was not the policy intention. I would thank Mr McIntosh for this observation and would intend to remedy this at stage 3 to reflect the policy intention of providing an additional method of service.
No, the issue that we've got to then face here then is this only relates to earners arrestments, right? So now we've also looked at bank arrestments. Now, currently bank arrestments, the way they're served, and also charge for payments, the way they're served, that the law relating to them is not actually in the Debt of Scotland Act. So there seems to be a bit of a disjointed approach. So as I said, I've explained how it currently is done in earners arrestments, where it has to be served by post, first of all. and if only that's not possible, then you can use personal service. But the rules in relation to bank account arrangements and both also serving charge for payments, they're different because those rules are contained in the ordinary course rules of the Scottish Sheriff Court, which basically means that personal service can actually be used even if postal service is available. Now, in terms of bank account charge for payments, for example, there's somewhere in the region of over 213,000 of these served each year, and under the current rules, if those are served through personal service, then that basically amounts to about £20 million in sheriff officer fees being added on to people's debts. In terms of bank arrests, there's probably about 200,000 of those executed each year, and if they're done by personal service, then you're talking similar amounts, maybe in the region of close to about 18-19 million pounds. So in total, when you actually think about it, if you look at bank arrests and earnings charge for payments, the amount of fees that can be getting added onto people's debts by sheriff officer fees could be in the region of about probably close to £40 million a year at present. And we don't have any figures. The sheriff officers don't share these figures. These types of service that is preferred by them isn't actually something that's reported on. But in theory, it could be, and I certainly know from experience that nearly all charge for payments have used personal services used for this. So one thing we could do in this, one thing I would like to see the Scottish Government basically doing in this legislation is harmonising the rules in terms of how wage arrests, bank arrests and charge for payments are served, and basically taking the position that it's the current position, which actually basically means in terms of wage arrests, which basically means that postal service should also always be the first sort of port of call. The sheriff officer should not be serving documents basically personally unless it's not possible to serve them by postal service or by digital or electronic service. Now, if they were to do that, then that would basically almost half the amount of fees that have been added onto people's debts by sheriff officers. And that could be a substantial amount. I mean, we could be talking anywhere between 10, 15, 20 million pound a year, less fees getting put onto people's debts in Scotland, and just by adopting a more proportionate sort of a way of doing this. And I would like to, Tom Arthur, the Minister, has said he's going to bring forward that change for earners arrests. I would really urge him to consider bringing forward that change as well for both charge for payments and also for bank account arrests, because surely, when we've got a cost of living crisis, when people are struggling to pay their debts, the last thing we need to be doing is adding tens of millions of pounds more onto those debts from sheriff officer fees, when a more proportionate, less intrusive, less expensive form of service could quite easily be introduced instead, similar to it's already been done for earners arrests. There's lots of other things I would also like to see, but unfortunately, this podcast, I just don't have enough time to go into them all. But I think the key point we've got to take from this is that this current piece of legislation, the Bankruptcy and Diligence Bill that's going through the Scottish Parliament, is very disappointing. It's very light. It's lacking detail, and it really is a missed opportunity to really tackle the issue that we're facing at the moment of lots of people suffering through problem debts. And the only sort of conclusion I can come to in terms of why we've got to this situation, why we've got this bill here, is that going back to what Kate Forbes says. I just don't think the Scottish Government, have any big ideas or big thoughts on how we tackle problem debt. And it's a bit like Kenny Farquharson said, the journalist, I just don't think they really are capable of doing the hard thinking to solve the hard problems that we face in society. But we can only hope that might not be the case, and we can only hope that as the bill goes through stage 3, that we may see some more amendments being brought in, more protection being brought in to help people, and we might hopefully see Humza Yousaf and the rest of the Scottish Government and Tom Arthur getting behind some of these amendments to hopefully make Scotland a fairer place for people to live in when they're in debt.